Good morning. My name is Jennifer Nager. I'm the chair of Reinhart's Food and Beverage Law Practice. And I'd like to welcome all of our attendees here in the audience, as well as all of the people online who are joining us. We have a great program lined up for you today, and we hope you'll leave here this morning with solid strategies that you can use to avoid immigration-related problems, such as I-9 compliance issues and naturalization discrimination. Our presenter today is Ben Kurten, who chairs Reinhart's Immigration Law Practice, and he's shareholder in the firm's Labor and Employment Group. He has more than 17 years of broad-based immigration law experience. Throughout his career, Ben has helped large multinational corporations, small private companies, and individual investors successfully navigate complex U.S. immigration laws in order to meet their business needs. He regularly works with clients from a variety of different industries, including manufacturing, healthcare, financial services, technology, and agriculture, and we're pleased to have him speak with you this morning. To our food and beverage focused audience. Before we get started, I'd like to take the audience through some quick housekeeping procedures. Our online attendees may ask questions by typing them in the questions section of the webinar control panel. Ben will answer as many questions as he can at the end of the seminar. If you'd like to follow along with a hard copy of the presentation, please check your email inbox. A copy of the slides were emailed to you, all attendees, yesterday. And for our online audience, volume can be adjusted using the volume control on your computer or phone. With that, I'll turn it over to Ben.
There we are. Hello, everyone. Thanks for attending. Today, we're going to kind of go over a mix of generalities and then also specifics. So some of you that are a little bit more experienced in the I-9 and sort of onboarding procedure with that immigration twist, we're going to kind of go over some of the ground rules, but also be patient with us because I'm going to go over some specifics today. I'm especially going to try to get some real practical tips for you that you can use on a day-to-day basis. Because what we're doing in this realm when we're talking about I-9s and what we can do when we're hiring individuals in the immigration complex, we're juggling compliance with going too far and getting into that area of discrimination. And I know employers are always struggling with, well, how far can I go so that I can both protect myself and my business, but then also not discriminate or just be unfair or get a bad reputation in my industry when I'm hiring people asking about their immigration-related background. So with that, we'll kind of go over some general things I have up on the slides. This is obviously our one big law that we're dealing with, sort of the underlying law to a lot of this. We'll go over some of the other more discrimination-related laws as well, but the Immigration Reform and Control Act of 1986, PIRCA as it's called, that sets the main requirement, imposes penalties on employers who knowingly hire or continue to employ persons who are not authorized to work in the United States. So when Congress passed that, that's what kind of created the Form I-9 rule. So we have just a basic, let's just go through some basic requirements. So anyone hired after November 6, 1986, they must complete Section 1 of Form I-9 no later than the first day of employment. So that's been interpreted as the first day of paid employment. You can have an employee complete an I-9 Section 1 with you before their first day, but it has to be after they've been given an offer of employment. So there's some subtleties there, but it at least has to be on the first day of paid work. That's when you have to usually have them into the HR office and you begin the process. One of the basic requirements is that we have to examine original documentation to establish the identity and work eligibility within 3 business days of the first day of employment. So we'll get a little bit more on this when we were talking about sort of best practices, but one thing to always keep in mind is you always have to look at those original documents. So people out there with multiple restaurants or processing plants and locations across the country, that's something to keep in mind is that you have to have an individual either an employee or someone you designate looking at people's actual documents. You can't get them scanned, you can't look at them, as we're doing on video conference. A human being has to look at a physical document for the I-9 process. And then you have the 3 business days. So it's sort of now been stretched out to what they call the 4-day rule. So first day and then within 3 days after that. And then, with the I-9, some of you, hopefully everyone's familiar with it, but if you're not in HR, you might not be as much. There's various different sections of the Form I-9, 1, 2, and 3. 1 is for the employee to complete, and 2 is for the employer to complete. 3 is sort of the re-verification, rechecking, changes type section of the Form I-9. And so that section 2 is what the employer must complete, looking at that individual's original documentation. After that person's brought them in, you complete that section 2. So one of the risks that we have with completing the Form I-9 and during the onboarding process is what documents can we demand, should we demand, how should we go about informing employees how they need to provide us with documents to show that they are who they say they are and that they're authorized to work in the United States. So with the I-9, what you need to look at are their lists. Their lists, they're both on the website where on uscis.gov with the Form I-9. They're also part of the Form I-9 itself. There's a list A, there's a list B, there's a list C. So list A is sort of a list onto itself. If the document's listed under list A, and it can be multiple documents too, or a combination. So if you either get that one document or that combination of documents listed under list A, that's okay. Or then you have to do sort of a twofer. You have to get a document from list B and you have to get a document from list C. And those 2 documents sort of combine to qualify. Where that comes from, list A is some government document generally that goes to the person's identity and also their immigration status. Are they a citizen? Are they authorized to work here? Are they a permanent resident? Are they an H-1B worker? But list B and C, C is sort of the documents that establish your ability to work, and list B are sort of who are you. So your driver's license doesn't say most of the time that you're authorized to work in the United States, at least now they don't. So we need another document. You have to get a list C document, and it might be an unrestricted Social Security card. And one of the things, again, that we'll go through again later is that you can't ask for too much. That is a risk. You might be thinking, gosh, I'm just going to be really safe, make sure that I don't make any mistakes, but what that can get you in is a little bit of trouble, as we're going to go through in just a bit. So IRCA prohibits immigration-related unfair employment practices. So when Congress passed this requirement, sort of putting all the weight on employers that they have to enforce the U.S.'s immigration laws, which is a whole separate topic of discussion, whether the appropriateness for that, they said, okay, well now we're making employers do this, but then we don't want employers to go too far, to have discrimination problems. So Congress, and that's probably where the imperfect system started, there's no perfect way to balance those 2 things. You can't be the cop and the benefits person at the same time. It's kind of just an inherent conflict. But unfortunately, that's what you all out there have to deal with, and it's what we as attorneys have to deal with in interpreting and helping guide you through. So there's a bunch of different areas that you cannot discriminate against. One's national origin discrimination. That's with respect to hiring, firing, recruitment, or referral for a fee. And IRCA covers sort of a limited scope of employers, because then we have Title VII, which is sort of a companion, but it's separate area law that goes to basically larger employers. So there's a little narrow group that IRCA covers just itself. So you can't discriminate against. What that kind of gets to is you look like you're from Canada, therefore I'm going to make you give different documents, or I'm just going to think, oh, well, all these Canadians are invading Wisconsin, and so I have to be really protective of all this. And, well, what if that Canadian citizen is also a U.S. citizen? So you can get discrimination in there. What if they're a permanent resident? So we can't just assume because of how somebody looks or where they're from or their dress that we can somehow ask for more or different documents from them or make them go through a separate process. That ties right into the document abuse. So document abuse can be those rules, any set of employers with 4 or more employees, so that's going to be basically any sort of business that's out there in the public. Most people have, you might have some small family-owned cleaning or other businesses or real small trucks, food trucks that don't have any, but most of you with processing plants and restaurants and other related industries are going to have 4 or more employees, so this definitely applies to you. Then there's citizenship and immigration status. Again, goes to the usual hiring, firing, recruitment for a fee. And this goes to a special class, basically says you can ask for more or treat this special class of people differently. And that's the protected people, that are U.S. citizens and nationals. Nationals is sort of a subset. If you're Pacific Islanders and all that will fall into that sort of a small group. Permanent residents, asylees, refugees, and temporary residents. So asylees and refugees are basically people who have come to the United States under crisis or to avoid just threat of their life in another country. So in Wisconsin and other areas of the Midwest, we actually have pretty large refugee and asylee populations that various groups bring into the United States. So it can get tricky when you're hiring those groups because they have very different documents in some aspects. And then also some of them are inherently authorized to work and they may not have the documents that you think they should have. So that can be a real, can be complicated and a real red flag area as to how you deal with them. And then there's certain temporary residents that are under some agricultural bills that we don't typically run into, so I won't bore you all with those. But be that as it may, there is a special class of people that have a little bit of special treatment. And then also, of course, sort of the whistleblower provisions. If there's a ICE investigation or a Department of Labor investigation or one of the other many agencies that can get involved in this, obviously you have to talk to the council and you can't just fire the person because they made a complaint or treat them differently or somehow harass them. I mean, that's pretty standard in all the discrimination type laws. And the penalties can be pretty severe. They kind of start low and they go high, and you can imagine where the feds end up most of the time, and that's towards the high end, because they don't like to leave your place without a few dollars in their pockets. So starts with the sort of the form violations, missing, incorrect, not signed, something's not completed 100%, $110 up to a little over $1,000. The average that we seem to see with penalties from Immigration Customs Enforcement is right around $900. So that seems to be the magical number. They do have a system where they kind of point system where they give you a couple extra points for this, and then if you're sort of you haven't had any other violations and you've done some other good things in their mind, then you kind of you'll get some goodwill. But then if you have a high number of I-9 violations in proportion to your workforce, you'll get a lower assessment, and so then that's how they figure out. There's a whole spreadsheet as to how they figure out the fines. Then it gets a little bit more severe with the unauthorized fraud or unfair practices, so they can ramp that up to, starts at $375 and up over $10,000. And then the really nasty ones, the pattern and practice, and it starts getting into the criminal realm. And Homeland Security inspections, the Division of ICE that does the I-9, always would love to get somebody criminally if they at all can. So always keep in mind that when they're looking at you for your I-9s, that officer is always thinking in the back of their head, can I make this a criminal case? I'm not saying they're being mean about it, but that's their job, is to investigate and see, are these people doing stuff behind our backs? Did managers know? Did presidents know? Did they have sort of unusual hiring circumstances that would tend to show that they knew that these people weren't authorized to work in the United States? And there's many, many cases reported in the media or on ICE's website where they have gone after people. So just keep that in mind, that this is, real serious stuff. I'm sure all of you on the call know that, because you're here and are concerned, which I think is valid concern. So let's go back kind of today. What can you do as a good corporate citizen? You're trying to do your best to comply with IRCA and the other laws that may apply, and you're just trying to do the right thing. But what that can also get you in is trouble when you step over the bounds. And one of the big areas is over-documentation. And what that means is you've over-papered it, you've over-asked for it, you've not just kept it to that narrow proof of, I got just the bare minimum that I need to show that this person is who they say they are and that they're authorized to work in the United States. That's all the law requires. And so those employers who go too far, Congress has said, we want to prevent that, because it may appear to certain groups that they're discriminating against. It may prevent people who just have trouble kind of providing one type of document, but they have another type of document. They don't want that group of people to lose out on being able to work in the United States just because they don't have what the employer thinks is the ideal set of documents to show that they're authorized to work in the United States. So, sort of to summarize, over-documentation can be requests for more documents than what's required by law to complete the Form I-9. This gets back to that list A, B, and C. I want your permanent resident card, and I want your driver's license, and I want your unrestricted Social Security card. If you say those words, you're engaging in over-documentation. This gets tricky because some people will just dump their wallet or their purse or their backpack on your desk and say, I don't know, you figure it out. And it's kind of reasonable that people do that. It's not something that people necessarily deal with all the time, is showing that they're authorized to work in the United States. But we have to be cautious, because even if you innocently write down all those documents thinking, geez, I'm just going to put them all down, and believe me, I see that all the time when I'm reviewing people's I-9s, is there's something in List A, there's something in List B, and there's something in List C. And it's not mean, it's not intentional, but it's a clear violation. And while one government agency, Immigration and Customs Enforcement, is probably happy in some aspects, I mean, they recognize it's a violation of the law, but the more you're putting down to show that your workforce is authorized to work in the United States, you're making their job easier. You're kind of satisfying their mission to make sure that you're employing only people authorized to work in the United States. But we're going to get to another agency that's a beast of the Department of Justice called the Office of Special Counsel. That's sort of the left hook. And so when you're trying to comply, they're going to give you that left hook punch and say, oh, no, you didn't. And actually, Office of Special Counsel has now become one of the richest by fine judgment agencies in the entire federal government, because and some of their fines are dwarfing what the I-9 fines are. So we'll get over that, but always remember, not only do you get to deal with the fun of the right ICE, but you get the left Office of Special Counsel. So over-documentation can also be that you've rejected a document and said, I want a specific document. So this might be somebody shows you a driver's license and unrestricted Social Security card, but you're looking at them and they're fitting some profile in your brain, and you're saying, you know what, I want to see your green card. I know that these documents are okay, but I want to see your green card or your permanent resident card to be technically correct. That's over documentation. You can't do that. If the person that you're hiring gives you something that is valid under List B and list C, it appears to be valid. You know, you don't have to be a document expert, but you gotta, you know, make sure it's not just goofy stuff written in crayon and looking totally fake. But if a reasonable person on a business standard would think, hey, that's a Wisconsin driver's license or that's a California driver's license, that's the standard. So, you know, you're protected in one area on IRCA with it's a sort of a reasonable employer standard, but you can't be the super sleuth and say, you know what, I think Wisconsin has a blue background and this is sort of a teal background, so I'm going to reject it. I mean, it's a judgment call at your point, you know, and maybe you want to seek counsel or what have you, or seek other online resources. But if you're doubting a document, you want to make sure that you have some reason to doubt that document. You know, rational, most people are cooperative and they'll say, okay, I'll give you something else. But, you know, if it comes down to the carpet, it can be an issue, because if you should have accepted that document and you didn't have a good basis for rejecting it, then that could be considered a violation. And then in back of that, they might say, you know what, you didn't take that document because I looked like I was from Finland, and, you know, you got this thing against Finns, and, you know, that sort of, that's discriminatory. So you got to kind of be juggling all this. I know it's not easy. It's a nightmare, but it's just something that everybody who employs anybody, just about as you saw, I mean, the bar is pretty low for how many employees you have to have. You're going to be dealing with this. Another thing that a lot of people get into trouble for is asking for documentation, what we call re-verification, too many times. So we have to learn that we only have to re-verify certain documents, and we only have to re-verify at certain points. So that's why it's important, we'll get a little bit into this later, is to have a good tracking system so that you know when people's documents are coming up for expiration, and that you're tracking, you know, the identity document, as long as it's valid when given, the driver's license, if that expires, that's fine. You don't have to get them in to bring a new driver's license in. But if they bring in a H-1B document, an I-94, and that expires, that you have to keep track of. And so, you know, you have to familiarize yourself with what's in list A, what's in list B, what's in list C, what can I ask to be re-verified. So basically, it's the a list A document, unless they're permanent resident, that has an expiration, might get you into the need for re-verification, or a list C document that has an expiration on it for work authorization, that might make you have to So you got to familiarize yourself or talk to your counsel about what documents, when and where do I have to re-verify. And this is maybe where I put in the plug. I recommend to a lot of employers that they have an I-9 IRCA compliance policy. It's sort of more of a manual, because if you have a lot of people working for you, you have a lot of HR people, you have a lot of locations, if you have sort of a manual, a policy, people have something to turn to besides trying to dig online for it. They can have it in their desk, and they can say, okay, well, this is the situation. Obviously, there's thousands of different situations, but maybe it will fall into this general situation. What does my policy say I have to do? And then you can kind of have more consistency through your workforce as to when we're re-verifying, what are we doing for I-9 compliance, how are we keeping these I-9s, where are we keeping them, who's completing them, who's reviewing them, who's destroying them when we can, how are we destroying them. You know, these are all important things, because then when ICE comes in too, you can say, well, this, or Office of Special Counsel, this is why we did it. It's for a non-discriminatory purpose. It's because this is our policy. Obviously, you want to have that policy vetted, but you at least have something to point to and say, no, it wasn't just because they had darker skin or they had a certain type of dress on, or they had a certain type of accent. This is our policy. This is when we do it. This is how we do it. So just my plug out there. So again, here's our friends at Office of Special Counsel that I mentioned. There used to be only one I believe, it was down to like one individual employed by Office of Special Counsel. Now they have plenty of attorneys, and they've really ramped up their enforcement. So there's always potential for Office of Special Counsel enforcement action, but it's enhanced when an employer engages in or appears to engage in over-documentation based on an employee's actual perceived national origin or citizenship status. So they can be called by individuals. There's a hotline. They can be called by enforcement agencies. The Office of Special Counsel has memorandums of understanding with most other enforcement agencies, including Department of Labor, Homeland Security, USCIS, all their divisions under Homeland Security. And I just want to kind of caution, because this was in D.C. not too long ago, and some of the heads of the agencies were there, and everybody's talking. And one of the things that's kind of coming out more is E-Verify, and we'll get into this maybe a little bit more if we have time. But E-Verify is the online system that you can basically plug in a bunch of information about an individual as part of the I-9 process. It's not, you don't have to do the I-9 process. If you do E-Verify, you have to do both, at least for now. Congress may change that at some time in the future. But all that information is going into the E-Verify database. And believe me, when the federal government gets data, they don't just ignore it. So what we're finding out is that Office of Special Counsel has an agreement with the E-Verify people, part of Immigration and Customs Enforcement, where they're data mining to see if there's a certain profile of the E-Verify. So they're compiling that information. So one of the areas that they've talked about to be especially aware of is if a disproportionate number of your employees that you're E-Verifying are all permanent residents. That can be a red flag in two different ways. And sometimes it could just be that's who's coming to your place of employment to work. But to the feds, it can mean two non-good things. One, either that a lot of these people are probably illegal and that these are fake permanent resident cards, because they're still, unfortunately, relatively easy, for lack of a better term, to get fake cards. And the employer is just not being careful enough, so we need to send an ICE agent out there to say, hey, are you guys, what is this? Is it just coincidental? Is it because you're not completing the I-9 properly? Or is it because you know that these people aren't authorized and there's a scam so that everybody coming in the door knows if they bring us anything that looks remotely like a permanent resident card, we're just going to let them in the door? The other side of that, too, is our employers that have this exceptionally high number of permanent resident cards, are they forcing these employees to present only their permanent resident card? Kind of goes into that little scenario I gave you earlier, which is, I don't like how you look or whatever. I just have this funny feeling. I want to see your permanent resident card. I'm not going to take your driver's license or your unrestricted Social Security card. So Office of Special Counsel is looking at that saying, aha, a couple of things might be happening. One of them is of our interest. Is there discrimination? Is the employer only allowing certain types of information, which is a violation of IRC under that over-documentation? So let's just maybe go through some tips. I've kind of alluded to them, but I think it's always good to hear them. Where they say 7 times is, you need to hear it before you learn it. So I think we can go over these. So never demand that an employee present a particular document or set of documents from the I-9's list of acceptable documents. So you don't want to have an offer letter or any kind of immigration onboarding that says, thank you, we'd like to offer you a job, and please bring in your driver's license and Social Security card. You can't just restrict down to those documents. That can be over-documentation, and I see this a lot, and it scares me because I kind of know the consequences, but I think it's very common. So, but it's wrong. So you don't want to do that. You could For non-immigration related reasons, you could make them bring in a driver's license so that you can verify who they are and various other things. You could make, and this is another point we'll talk about, make them bring in a social security card because you need to do it for tax reasons. But you can't dictate what documents people can bring in to complete their I-9. A better practice would be this company or this restaurant follows immigration rules, including IRCA. Therefore, on your first day of employment, we're asking you, we will be asking you to complete a Form I-9. Please be prepared to bring in any of these documents that are on this copy of the I-9 with the List A. Please either provide something from List A or please bring enough documents so that you have one document from List B and List C. It's up to you to choose what documents you present to us. We cannot tell you which documents from these lists you have to bring in. It's a lot, but if you kind of put it out there in writing, it's going to, one, prevent confusion from individuals when they have an offer letter. They're going to know when they're at home, okay, I got to dig up these documents so that on Monday I know what to bring in, or at least by Wednesday I know what I have to bring in to get the I-9 completed. And then you don't get them just dropping their wallet or purse or backpack on your desk and saying, you guys figure it out. Then you also have written policies or a document saying, don't do this, and we don't do this. So you have a bit of protection there. So a little pointer. You have to verify that the original document provided by the employee are on the current list of acceptable documents. It's changed. It hasn't changed in maybe 2 years, but you always have to update it. So those of us who've been around a little bit longer will remember some documents that used to be fine but are no longer. So you want to make sure that you're up to speed and that they appear genuine and related to the employee. So the picture has to look like Ben and not like Susie. The document has to look like a real Wisconsin driver's license or a real permanent resident card. There's lots of resources out there, none perfect, but there are at least some out there that you can check and see what, USCIS has pictures of what a permanent resident card, what a passport, what 994 looks like. You can go to most state DMV offices and somewhere on there you'll see what their typical driver's license or photo ID document a lot of states have now that aren't just for driving or can't be used for driving, but what their photo ID. So if you're doing multi-state hiring, you're going to have to, I think it behooves every employer to be at least, relatively familiar with what the documents that are used in their state look like and what the valid documents and if there are any changes. Again, even ICE will say, we don't expect you to be document experts. And in fact, sometimes ICE isn't document experts because when I have I-9 investigations, they'll say, no, that's a fake document. And I'll say, no, it's not. They'll double check, triple check, and then in the end they'll say, oh, you know what, you're right. It was a real document. I mean, they're tough. There's been so many changes to these documents over the years. People can come up with some really old, funky ones, and so there can be some verification that's required. They have to be unexpired. That's a change. You cannot accept any document that has an expiration date on it if that expiration date has since passed. They all have to be valid. The I-9 has plenty of lines on there for writing down the expiration date on there, and you have to write that. You also have to write what agency issued the document to the individual. So you can shorten it to Wisconsin DMV maybe or some other thing because there's not a lot of room on there, but you can't just skip it or be completely unspecific and just say Wisconsin. Well, that's really not an agency. That's a state. That's a geographical designation. What agency? Wisconsin DMV. That usually will satisfy most ICE officers, subject to, of course, their whims. Again, this goes back to never require different or additional documents for employee or group of employees than what the Form I-9s require. So you may have good intentions, but don't do it. You can't, or where it's sort of unbelievable when you read it, but I guess I could see how it happens, just trying to be overcautious. You're hiring a certain workforce. That workforce may have a certain ethnic background just because, word of mouth, hey, this so-and-so's hiring. They tell their friends, families, colleagues. that they live around communities. And so you get a high population that might be Finnish, they might be from Mexico, they might be British. I mean, it's just whatever. You can't treat those different groups differently. You may have, or one of your HR managers or onboarding people may have a prejudice one way or the other. I mean, we are human. But we, as managers, and again, back to the policy, is you can't treat different groups because they look differently, sound differently, act differently in the I-9 context. Everybody gets to bring in this type of documents. If they're on the list, they get to present them, as long as they appear genuine and related to the person who's presenting them. One of the areas of confusion is that you can't use a future expiration on a work authorizing document alone to say you're not going to hire somebody. Because a lot of those documents can be automatically renewed, or they're more of a, this gets into some of the complicated refugee asylee documents, which I'll spare you, but if you run into that, give us a call. But some of those documents, they have an expiration. That document might expire, but that person's authorization to work lawfully in the United States itself does not expire. So there's been a lot of back and forth on this, but sort of the consistent rule is that alone doesn't mean, if you're like, well, your document expires in 6 months, I'm not hiring you, that will generally be considered a violation of IRCA. You can decide as an employee you're not going to sponsor somebody for a immigration benefit such as an H-1B or an L-1 or E-1 or one of the letters out there. That's a bigger part of my business is getting those, but you can sometimes decide not to sponsor those, but it's very dangerous, and you see a lot of it. Even big institutions that say, no, we're not going to get it. If you write down the expiration date, you track the expiration date, and if you need to re-verify, you can send a reminder to that person and say, hey, you know what? Your X document is expiring in 3 months, your EAD. We want you to be aware of this and make sure that you're doing what you need to get it. You can give them a helpful hand, but and then it's up to them. If they don't have it, then they can't come back to work until they have a new document that says that they can work. And it's unfortunately just a risk of business out there. So it's very frustrating, I know, but it's one of those areas where companies have gotten themselves into trouble. You have to be timely when you're re-verifying. Again, not too early and not too late. But this gets into, making yourself familiar with the documents that you have to re-verify. So the general rule is permanent residents don't have to ever be re-verified. They might have a 10-year permanent resident card, but that gets back to sort of what I was saying, where that's just a form of ID. It's not authorization in of itself. So you can't re-verify most permanent residents. Now, of course, there's a few exceptions. Conditional residents, people who come in on an immigrant visa. I mean, talk with your counsel, look online with the handbooks. If you do encounter one of those situations, but I guess my point for today is don't have a carte blanche rule of we re-verify all people with permanent resident cards, because I can think of several cases by Office of Special Counsel where all the fines were over $100,000, where people had a pattern and practice of re-verifying permanent residents. Citizens, again, never get re-verified. So it's just, we have to be cautious in that. So again, it can be like, I want to really do a good job, but we have to kind of temper our enthusiasm to do that. Sometimes you have to, though, re-verify. Obviously, if a work authorization document is expired, and it's one of those types of documents where, yes, once that expires, they actually can't work in the United States. They don't, and what they call EAD document for a lot of students, a lot of you might run into, when that's over, it's over until you get a new one. If the document is missing or incomplete, I mean, we always suggest to people, you want to be doing at least annual or at least every couple of years review of your I-9s. Make sure you have them. Do a list of your current employees, do a list of your currently or your recent firings or people who have left. Make sure that you have an I-9 for everybody who's a current employee. Make sure you have an I-9 for everybody who's left recently or was terminated recently. And if you find out that you have missing documents, I mean, check with counsel maybe before doing it, but you just might have to complete an I-9, because it's always better to have an I-9, even if it's late, than no I-9. Nothing makes ICE matter, and it's easier for them to go after people than a missing I-9. If it's late, they'll say, hey, at least you caught it before we caught you, but you realized it. It looks like you're looking at your I-9s. It looks like you know what an I-9 is, so you did it late. I've had plenty of times where there's no fine, or the fine is nominal in comparison to what it could have been if they just didn't have it at all. So really important to keep up with that. Or it gets into if it missing or never existed, I guess sort of the same thing. But either way, you got to take care of it, or was destroyed. I've had clients call and say, you know what, we moved and we burned all of our I-9s by accident because they were in this one box, or they were shredded. You got to start over, and it's not discriminatory, but you have to, you know, the re-verification is everyone gets re-I-9. You know, again, this is tricky, but talk to counsel, make sure you can show we lost them all. We're doing all the I-9s, whether you're the president or a line worker or a sous chef or a processor. We're doing everybody top to bottom, or whatever. If we lost certain letters, you know, people's names between this and this. I mean, you have to document that you're doing the re-verification in a non-discriminatory way, and that you're doing it out of business necessity. And then, of course, there's always the notice from ICE when you might have to redo it or go through the gymnastics of asking for new documents, having ICE double-check them, and then complete the I-9s after that. Again, so list good practices, list B documents. Those are the ID documents under the BC scenario. If they're valid when the person provided them to you, like a driver's license, you don't have to track that driver's license. Say, hey, you know what, your Wisconsin driver's license expired. You filled out your I-9 7 years ago, but now you have a new driver's license. No, you don't have to do that. So avoid that mistake. That's fairly common. Again, back to, so citizens getting just, you know, again, to that sort of never re-verify the citizens as long as their I-9 was properly completed. If there's information that's missing, you can come back to them in certain circumstances, or if it was never completed or was lost, you can obviously do it. But again, we have a way of communicating that. A lot of this is packaging to your employees. Permanent residents, very few you have to re-verify. Check with counsel before doing it, or at least check the handbook. Then you'll know who you can or who you can't. When you're re-verifying, because you have to, one thing that not a lot of people realize, it's that individual employee's choice as to what documents they're going to present for re-verification. So if they've changed status in the meantime, and now they had a permanent resident card only when they were hired, they don't have to come back to you with a permanent resident card. If they want to show you a driver's license and an unrestricted Social Security card, that's their prerogative. You write it down in Section 3. You're covered. Everybody's happy. You can't tell them, no, you gave us a permanent resident card before. Now you got to give it to us again. So be cautious with that. Can't, again, from what we were saying at the outset, specific combinations or for whatever reason, just because it's easier or just because you like a certain document better. If it's on the list, they can do it. Again, re-verification gets back into that. You can't just, if you lose them, just target people, employees you've always suspected were illegal or something. It has to be top to bottom or whatever the non-discriminatory reason. We lost this set of documents, or and you can never, unless they're lost or destroyed, you can never just sort of, the rules are right now, you can't just say, you know what, we don't like our I-9s, we're just going to redo them all. You can't just redo them all. You have to have specific reasons. Information's missing, I-9s are missing, information is incorrect. You can't just, you know, get scared from a seminar like this and then run back. And unfortunately, it'd be great if you could. Go back and redo all your I-9s. You can try to fix your old ones. You can complete new ones for the ones that are missing. Visually examine, again, this gets a little bit back to what I was saying. If you have multiple locations, multiple HR people, You can't do things, unfortunately, right now electronic, through Skype, through video conference, through fax. It's surprising how many places do this. Oh, I hired a sales manager out in California. They're the only people out there. I just had them fax a copy of their driver's license and social security card. My stomach turns. That's wrong. Can't do that. You could have them go into a law firm that you hire out there or an HR firm out there, and if you get a human that you've designated to look at that document, they complete the I-9 with that individual. I mean, you have to have a human that you've designated that is authorized, is acting on your behalf, look at the physical document with the employee and then complete everything. So that's a frustrating rule, but it's just one of them out there. So I'll just quickly go into Title VII. This is, again, one of these big discriminatory, anti-discrimination, I should say, rules out there. Most people are aware of it. Applies to bigger employees, and it's the usual race, color, religion, sex, or national origin. Terms and conditions of employment, can't retaliate. And one thing to realize under Title VII that I'd just like to bring up, point out is it doesn't matter the person's immigration status. Some of the IRCA rules only apply if they are authorized to work in the United States, so they're one of the protected class. But Title VII, it doesn't matter. You can't discriminate against them. So this is sort of a back way of people coming after employers for discrimination. So we're going to go through this. A lot of people ask, well, what can I ask at the hiring? It's very limited. So I have some text on the slide there as to sort of what's been blessed by Office of Special Counsel. If you vary it, I wouldn't vary it too much. Basically, you can't ask a person's specific citizenship or status. You can inquire into it, and basically that is sort of to give yourself a heads up. Then you can say, well, do you need work authorization? Yes, I do. Do you need me to sponsor it? Yes, I do. Okay, well then we have to talk to Ben about getting you an H-1B or doing something else. It kind of, I think that would be fair. It opens the door. The person needs your help. But if they say, I'm authorized to work and I don't need your help, then it's going to be up to them on their first day of paid employment to bring in the goods and to do it and to show. And if they're not, then you have to turn them away until they can come back. So you can kind of get a little protection. I know it's very frustrating to make an offer and then find out later you got to sponsor somebody. So this is one way to kind of do it, but you can't go too far. Can you tell them that you're not going to sponsor? You can, but you have to be consistent in doing that. You can't just say, I'm going to sponsor these type of people and not these type of people, unless it's doesn't fit into one of those protected classes. So it can't be race, nationality, but you can say, I'm not going to sponsor H-1Bs for low-skilled positions, low-paid positions, but I'm going to do them for high engineering. There might be reason to do that. You can maybe work out a legitimate reason for doing that, but you have to be cautious. But you can tell in advertising, it's fine to say we will not sponsor individuals for immigration status, because that's an expense, a business expense that you can decide to not do, but you have to do it neutrally and not pick and choose. Oh, we won't do it for some, but we'll do it for the Latinos, but we won't do it for the Asians. Or you can obviously get a lot of scenarios where this might, if nothing else, look really bad. It goes back to this. May I ask an applicant how long their work authorization is valid, and may I then refuse to hire when I find out there's an expiration date? Again, I won't go back over that, but generally no. If they don't renew it or they can't, then they lose their job, but you get into some dangerous grounds if it's a future expiration. Now, this is slightly different than, well, what if I have to sponsor them with an H-1B? There can get into other neutral business expenses. The person has no H-1B time left. I don't want to hire them. It's very expensive. I mean, it's not because of who they are or their nationality. It's just, it's a business decision. So again, talk with counsel. Every situation is very different. So I don't want to overly generalize, but there might be some leverage in there. Again, may I terminate an employee for not disclosing that their ability to work in the United States is unrestricted? No. You can enforce truthfulness policies to a certain extent. But again, if the fact that you are firing somebody just because you have to, they have to renew their work authorization, that can be found to be a violation of IRCA. May I require all job applicants to be able to read, write, and speak English? To a degree. It's fairly limited. This is where Title VII gets involved. It basically is to, you can restrict it as to the nature of the job and sort of what is required for bona fide safety work requirements. If you're a salesperson, you know, you have to be able to speak English. If you might be able to say you're working in this certain high danger area, you have to be able to read basic English to read the safety things. And again, we'll have to, you know, talk with us, talk to our labor and employment attorneys. You have to have certain policies, but you just can't say, must be absolutely fluent in English. Well, why? Well, there's no reason. And half of our managers speak this other second language and can communicate perfectly fine with that employee. That's where it starts to look like discrimination. So you got to have legitimate job-related reasons and really tailor any English language reading, writing, speaking requirement very narrowly, or you can be crossing some lines. May require that everyone have a Social Security number. You can, but again, it's all the matter of degree. You can actually begin someone's employment without a Social Security number if they can show that they're applying for one and that they get one. If they never get one, then a lot of times there's grounds for termination. It's non-discriminatory. If, you know, IRS is going to come knocking on your door if you never reported their wages and can't match them up. But it's not just a hatchet fall. If you don't have a Social Security number on the first day, there might be other certain circumstances. In E-Verify, if you look under E-Verify guidelines, you know, you delay the E-Verify process, and then there's a way of putting in the information that the E-Verify for this individual was delayed because they were getting their Social Security number. So again, just don't automatically assume that you can not hire somebody or tell them to go away if they can't present a Social Security number. And in fact, a Social Security number is not required for the I-9. It's sort of a voluntary, unless you're doing E-Verify. And just because somebody has a Social Security number, one, does not mean that they're automatically authorized to work in the United States, because it might be restricted. And two, just because they don't have a Social Security card at the moment doesn't mean that they're not authorized to work in the United States, so be cautious. May I have a policy of only hiring U.S. citizens? Very, very restricted ability to do that. Basically, you probably know already if you can do it because you're in a high-risk, government-oriented, you're making bombs or high-security, fancy aircraft components that, I mean, it's got to be by federal, state, or local law, and unless you're catering to the military or some sort of national security infrastructure, I think there's very few employers who can get away with having a U.S. citizen hiring only policy. And as an immigration attorney, I say to a lot of people, you're kind of shooting yourself in the foot with that policy. You may feel like you're saving, but there's a lot of people with a lot of great talent and expertise out there who aren't U.S. citizens. So showing my bias a little bit that way, but unless you have to, and you probably know it already because the feds are telling you when you get your contract or you start working for them, that's the way it's got to be. And then you have cover. If the feds say you have to, then you got cover. May I choose to hire a U.S. citizen over hiring other protected individuals? This gets into, there's been acts in Congress trying to push one way or the other, but basically is you don't have to. You can, but you have to look at the qualifications. You must truly compare the credentials of two individuals and cannot simply presume that the U.S. citizen is more qualified. Again, that gets into you just can't assume. As proud as we are of this country, which is the greatest on earth, that its citizens are automatically more qualified than everyone. If somebody has authorization to work in the United States, then you got to give them a fair shake. This is, I think we'll be getting close to the end here, but one of the big issues that's kind of come up is, may I terminate an employee who originally provided me with false information, and I'm basically learning it later. They've come to me and they've said, you know what, I have a new Social Security number, I have a new name, I have all this new identification information, because now I'm authorized to work in the United States, and I wasn't 7, 8 years ago when you first hired me, so I'm basically lying to you. What you want to make sure is that you have a truth in hiring policy and that you apply that strictly. No exceptions. Office of Special Counsel has kind of gotten this in its crosshairs, and we used to give guidance that was a little bit more like, sure, you can, not necessarily, but it was a little bit more free to just. Now I think, because I think that the tides have changed a little bit, it might change, the whims of immigration law in the United States are very subject to political pressures, obviously, and all that, but you have to be cautious. And so if you're going to terminate somebody, which obviously that person put you at jeopardy for an ICE, violation, you're mad, you don't know what to do, who are they? You got to have that consistent truth in hiring, say, you know what, you lied to us, and we apply this. So if somebody didn't disclose a felony and they should have under whatever rules, we would fire that person. So you might be called to carpet to show that you're doing this uniformly, and just because, and not just do it when it's an immigration related one and they might be a particular skin color, pattern of speech or dress, and those are the only people who lose their jobs. But everybody else who lied to you, that's fine. As long as you tell us the truth, we don't care. You can't get into that. So be cautious about that. Talk with counsel. And again, this gets back to the importance of having not only immigration policies, but labor and hiring policies, and that you train your staff to apply them consistently in a non-discriminatory way. And then you just pray and hope that you make it through this crazy world of the right hook and the left hook with the federal government coming after you, and also trying to make some money along the way. So we completely understand that it's not easy. It's tough, but we appreciate you out there doing that, working hard, and giving us all the services in the food and beverage industry and other related industries. We certainly all enjoy food and beverage. So keep it up, and we here at Reinhart are here to help you if you have any other issues. It can be very complicated, so don't hesitate to give us a call or shoot us an email. And I think we're going to be wrapping up here, and we might have a few questions if we have time.
We do have a few questions from the webinar, folks. Okay. The first question is, so what do you think of E-Verify? Should I enroll my company in it?
Okay. That's a big topic, but I'll just kind of give you the real quick down and dirty. I think E-Verify is sort of the wave of the future, and it might be unavoidable. There's certainly Senator Grassley and some others are trying to make it unavoidable. So I think a company should evaluate what their situation is, what their workforce, what their hiring, what their HR capacity is, because it's some work, it's not as much work. Kind of depends on what industry you're in, but it's I guess with time, now that's been out a few years, I don't think it's as horrible as it used to be, but you have to be prepared, and you have to be prepared to follow its requirements very closely, and you have to be aware that they are mining that data. So I wouldn't just do it for a silly reason or just because one person suggested it. I think an employer really needs to vet that decision and make sure that they're getting into what they know they're getting into before with E-Verify. But it's also the train coming down the track that I think is going to run over a lot of us. And so some employers, it's just nice to start the process so you get that familiarity. It certainly helps with I-9 compliance. It certainly helps with ICE investigations, either if you enroll shortly after getting a visit from ICE or ideally long before they come, because they look at that favorably. So I think that's certainly something that you should look at, not dismiss E-Verify, but also not just sign up at the whim at 3 o'clock on a Friday.
Hey, one more question. Doesn't an employee need a Social Security number to begin employment?
Okay, and that gets back to, sort of covered it in the slide, and that's fine to bring up again, 7 exposures. No, they don't need it. You can require that they eventually have it, but I would suggest the IRS on their website actually has a really great summary of what you need to do. You can, the person has to go and apply for it, and they bring you back information, and then with the 941, you just indicate that it's being applied for, and you go through this rigmarole. And also with E-Verify, you can delay it, but that gets to be sometimes a call with counsel as to, it's been going on this long, what can we do? And then we have to evaluate the circumstance, try to be reasonable maybe sometimes, it all depends. So just don't automatically, though, assume, again, that they have to have a Social Security card, or that if they do have a Social Security card, that you're free and clear and don't have to worry about making sure that they also have authorization to work in the United States. Sometimes a Social Security card means that, sometimes it doesn't.
Great. Well, if anybody else has any questions, please feel free to email Ben or shoot a question at the bottom of your screen, and we'll be sure that Ben answers it.
Okay, thank you.
Thank you very much.
Have a great afternoon, everyone.